Good morning, Your Honor. Tim Saxon on behalf of Kim Perkins. Yes.
Your name, ma'am?
Kim Renee Perkins.
Thank you.
Your Honor, this is a date and time for a PCC. We're asking for a preliminary exam date. I do have written and video discovery.
You have all the discovery, okay. People have their witnesses available the 6th?
I believe so. Well, we'll try our best.
Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry.
And Your Honor, if I may make a bond reduction motion.
Go ahead.
Your Honor, I'm asking for the bond to be reduced to a PR bond. Ms. Perkins is here on an allegation of assault and battery with Bridget Williams, her daughter. What I've seen so far in this, at worst, this was a mutual combatant. Ms. Perkins' top was torn off. She actually called 911 first, and then she wound up being arrested. The alleged victim also called 911. So this is not a foregone conclusion that she was the aggressor or would be a further problem. She has secured housing with her other daughter in Port Huron, so she does not need to go back, except for one time with a police escort to get her wallet and a couple of clothes, and she assures that she will be able to attend all future hearings.
Response?
Your Honor, I want to be clear. This is not a matter of assault and battery. This is a case of alleged felonious assault where the victim, Ms. Perkins' daughter, alleged that Ms. Perkins argued with her, fought with her, and tried to stab her with a knife, as well as scratching her face in the course of that incident. I appreciate that she has somewhere else to live. I would
Hold on a second. Do they live together?
The victim in this case was apparently allowing Ms. Perkins to stay with her at that residence. And
Okay, so they live together. All right, go ahead.
I would ask that bond continue. If the court sees fit to release her, I will request that she have a top zone tethered to this location. Additionally, I believe at arraignment there was a request made. I don't know if there's a checking order on this file. Ms. Perkins has a very long history of drug and substance abuse related offenses and convictions. At the time of this incident, she was highly intoxicated and incoherent as well. So I would be requesting that she is tested with all substances possible with some sort of or some other device as well. If she would.
What I'm going to do is I'm going to grant the motion for a bond reduction. I'm going to reduce her bond to a $2,500 personal cognizance bond. I will also indicate that the defendant is to report to community corrections upon her release for placement on a GPS hot zone tether. Since she's going to be set for exam, I'm not going to order testing at this time.
Thank you, Your Honor.
Court does call the case. People versus Cadavian White.
Christina Costantino appearing on behalf of Mr. White. Mr. White, can you please state your name for the record?
Cadavian White.
Have a camera, sir? Thank you. All right. What are we doing on this case?
Judge, this is a date and time set per PCC. We would be asking for a preliminary exam in this matter. Discovery is complete as to my knowledge.
People would have their witnesses available the 6th.
Perfect.
Preliminary examination in person, May 6, 2025 at
12 p.m. before you.
12 p.m. That's before me. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of People versus Diversier Hennings. If I'm saying that correctly. And I will also call the case of Seth Priester.
Christina Costantino on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Devasier Henning. Good morning, Your Honor. Wendy Barnwell, once again, P42505 on behalf of Mr. Priester. I don't see him on the screen. I know he's in.
Right. Could you unmute and then state your name, Mr. Priester?
Seth Priester.
Oh, there.
Thank you. All right. What are we doing?
Judge, I was just appointed on this matter either late last night or this morning. Given that I do not have any discovery at all, actually.
So you're ready to go.
I'm ready to go.
Yeah.
Hey, you know what? I always ready. But given that, to ensure I'm representing my client to the best of my ability,
Yes.
I would be asking for an adjournment of the PCC so I can obtain discovery and review it with my client.
Counsel?
Yes, Your Honor, I will go along with Sister Counsel, and I believe we'll return on May 15th is our proposed date.
Oh, so you're picking dates.
Only because I got it from you for the other case.
Yeah, I know, but again. Make that 30 out there, but Ms. Constantino, will the 15th work for you?
Yes, Judge, I can make that work.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue. I need green sheets on these, please.
Oh, I'm sorry, Judge, I do have it right here. Judge, would the court consider hearing a bond request, a bond reduction request?
I will always hear it.
Thank you, Judge. I'm told my client's bond is currently set at $250,000. We would be asking if the court would consider a lower bond, perhaps $100,000, 10%, with a 10% provision. He is 18 years old. He would be, prior to his incarceration, he had employment lined up at JMB Temp Agency. We are hopeful that he would be able to return or start that employment. He was also enrolled in an adult education GED course that he could continue. Should he be released, he would reside with his mother in Ypsilanti. She's very supportive of him. He has a significant other and a 2-year-old child that he does provide support for. It's my understanding that he does not have any prior adult criminal history, and he would be able to follow any and all no contact orders.
Response from the people.
I believe it's correct that he doesn't have any adult prior history. This is the case with Mr. Priester. He is currently charged as an adult. The history that I do see is that he apparently.
Mr. Henning.
This is your.
Mr. Henning.
I apologize. Sorry about that. They're called together, I guess. As far as Mr. Henning is concerned, Your Honor, obviously the circumstances of this matter, which would be the co-defendant in the armed robbery case, are concerning on their own. I will leave it to the court's discretion. I did want to ensure that if there's a no contact order on this case, that it does include Mr. Priester. Your Honor, just, I apologize for misspeaking earlier because the cases were called together, but Mr. Hennings does not have any adult history as was stated. His juvenile history does obviously include, not obviously, but includes some counts that were adjudicated in that manner, and he has had some felony charges that were pretty serious, I think, resolved with misdemeanors, the unlawful breaking and unlawful use of an automobile, breaking and entering, tampering with the tether. There's quite a bit here. So Ms. Constantino is correct that there's no adult history, but there's quite a bit of juvenile history here as well. That's concerning. Leading consistently going from 2020, looks like roughly 5 or 6 cases up through 2025, which is dismissed attempt in terms of activity.
Nothing, Judge. I would just suggest that $100,000 bond would, I believe, would account for even the juvenile history that's been mentioned.
On Mr. Henning's case, I will reduce his bond to 100,000. I will not do 10%. I will give the 100,000 cash surety.
Your Honor, may I address one for Mr. Priester?
Apparently, yes.
So, Judge, I am pretty sure that, well, I'll rephrase it. I was about to say something. But my client's mother is present in the courtroom. He has been living with her. I know that he was attending a program, I believe, several days in the week over here at Community Corrections, Judge. I do believe that the bond is excessive. And I'm pretty sure that this court understands the concept of a presumption of innocence if the bond is excessive. Thank you.
Response?
So returning to the argument that I was beginning to make earlier, Mr. Brewster, in terms of the juvenile history that we have, obviously he's still juvenile today, charges in the adult this armed robbery case. It looks like there were 5 previous petition requests in the past year and a half. Unfortunately, those were denied due to some evidentiary issues, I believe. It looks like on the most recent case we have with him, which is the 2024 matter, he did have a plea for home invasion first, UBAA, receiving and concealing a motor vehicle, and financial transaction device theft. So I think we have a plea after that on a separate case for another receiving and concealing stolen property.
Are you saying those were all juvenile adjudications?
It appears to be so, yes. I think this is the first one where he's been charged as an adult, if I'm not mistaken. The allegations in this case are not only armed robbery, apparently, that between the individuals involved in this, the victim was pistol whipped in the face. So I understand that this is a juvenile situation, but obviously these allegations and offenses are very concerning. So I would request that.
Anything else?
Your Honor, as to cases that don't meet the evidentiary threshold, so we still have a constitution that's very active now. And so I would ask, and this court knows there's a presumption of innocence to this. I don't believe that counsel has brought up anything that's violent or anything of that nature. I'd respectfully ask that this court lower the bond significantly.
In this case, so those previous juvenile adjudications in this case, which I think are a distinction between his co-defendant, I am going to decline to reduce the bond in this case. Motion for bond reduction regarding Mr. Priestley is denied. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Court calls case People versus Julian Ward. Yeah.
Christina Costantino appearing on behalf of Mr. Word. Sorry, Drew.
Julian Ward, present.
Judge, this is a date and time set for PCC. At this time, we would be asking to have this matter set for preliminary exam.
Just coming.
So this is, the bonder, she wrote to me, someone asking for her bond back, a second one saying that she did write her bond back. So
And she did not.
correct, yeah, I think the bond was signed. Yeah. So I don't think
So you're looking for a preliminary examination in this case?
Yes, Judge.
And you said discovery is complete.
To my knowledge, it is.
People have the witnesses available to 6.
That is fine.
Preliminary examination in person, May 6, 2025. 9 a.m. before Judge Barry. Bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Thank you, sir. Court does call the case of the People versus Stefan Scott.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Scott.
Your name, sir?
Stefan Scott. You're asking for a brief adjournment to review discovery.
Probable cause conference, May 6, 2025. That's a Tuesday, 9 a.m.
Discovery.
Bond continue.
You can't move forward without a discovery. Thank you, Your Honor. Appreciate it.
Court does call the case People versus Marika Philpott.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Ms. Philpott.
Ms. Philpott, can you state your name?
Me?
Yes, ma'am.
My real name is Teresa, but I do go by Marika.
Okay. We'll work with that. Okay, what are we doing?
Your Honor, I have to ask the court to adjourn this matter. I do have a green sheet. I did seek to visit Ms. Philpott yesterday. She wasn't up for company.
Okay.
If I could approach.
Yes.
But I will go visit her again.
I'll adjourn this matter to May 6, 2025, 9 a.m. That's a Tuesday. Bond continue.
And Ms. Philpott, I'll come visit you, but make sure you come up and see me, okay?
Hey,
Thank
All
you.
right. Thank you, Ms. Philpott.
yeah. What the hell?
Well, that's called the case.
Hold on, let me mute you.
Clerk calls the case, People versus Anthony Taylor.
Morning, Your Honor. And we have the people.
Morning, Your Honor. James Fifelski on behalf of Mr. Taylor, who's to my right. Please state your name.
Anthony Taylor.
Thank you.
Judge, I believe all discovery is in. We are asking the court to set this for preliminary examination.
Your Honor, may we approach briefly?
Why? Well, who's coming up?
Myself and Ms. Willenberg.
Okay, if Ms. Willenbring's coming, then yes.
I do.
You may come up. All counsel has indicated all discovery is complete in this matter. And we were discussing dates. I'll set preliminary examination in person, June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you.
I'll chat with you. I'm requesting for the house. I'll try to stop by and talk to you.
Huh? So cool. No, it's one of the ones with the big flat. It's gonna be, because you like those, so. You don't know? Oh, so if it shows up, you might like run out. Never mind. We'll talk later. Let's call the case. People of the State of Michigan versus Todd Emmerman. That would be fun.
I love this job.
Good morning, Your Honor. Jennifer Douglas for the people, P72748.
And good morning, Laura Yagi, Assistant Public Defender, sort of with, but mainly on behalf of Mr. Ammerman. Your Honor, Mr. Ammerman is on Zoom. I was just trying to be in a breakout room with him. My understanding is he's not in Your Honor Zoom. He's in Judge Freshour's Zoom.
Oh, that works.
It does not.
I know.
I don't know what's going on. I was,
Okay, all right, it's okay. Yeah. So what do you need to have happen? You need him to get to my Zoom.
So, Your Honor, I was going to ask for an adjournment anyways. I did fill out a green sheet. I would ask for an adjournment and to allow us time to get him in the right place. And
Our staff is not going to be able to communicate well with him to get out of their Zoom.
What's that? He won't get out of there.
They tried to send him text messages. But
So have you talked to him about signing into this Zoom?
I have not. I have attempted, but I have not been successful. And
Fresh Hour staff, I was just informed, are trying to communicate with him to get him to sign into the right Zoom. It's not going well.
that does not surprise me.
Well, okay. Appreciate your candor.
I really don't know what is going on, but
Shaggy, I'll let you out the hook.
Thank
Is there any objection from the people to the brief adjournment?
Your Honor, there's no objection. I don't have any information that suggests that we're doing it.
All right. I mean, he theoretically, I guess, is next door, so he. All right. Let's wait 1 week out. Can you explain this to him in a week?
I will do my very best.
All right. Probable cause conference, May 1st, 2025.
Thank you, Your Honor.
You're welcome, Ms. Aggie. Court calls case People versus Quentin Williams.
People, Your Honor. Pardon, Your Honor, Wendy Barnwell, P42505, on behalf of Mr. Quentin Williams.
Your name, sir?
Quinn Williams.
Thank you.
Good.
Okay, what are we doing?
I'm requesting an exam, Judge,
All discovery is complete?
upon information and belief. I believe so.
What's that mean?
I have electronic as well as paper discovery.
You're not available the week of the 6th, right?
One split second, Judge.
Well, you just looked it up before and said,
Yeah, I have to look at the actual thing.
go for it. I was trying to be nice.
I'm available on the 5th.
Okay. But we won't be here on the 5th.
Oh,
Well, I'll be here, but we won't be holding exams on the 5th.
okay.
It's the 6th or the 13th?
One split second, Judge.
I know the answer. It's going to be the 13th because you're not available the 6th because we've already gone through this. But that's okay. I'll wait.
Ronna, can you guys do it on a Friday?
Can I do what?
I'm available on the 9th of May.
Okay, good.
I mean, jury trial on the 13th,
Okay,
so I don't want to call that.
we do exams every Tuesday.
Okay. The 20th. Judge, come on now.
People have no objection to that.
When I'm available, guys, I'm in trials.
Preliminary examination, May 20th, 2025, 9 a.m. That's before, please. Judge Barr.
Available there.
We'll continue. Thank you.
Okay. Thank you. All right.
Court calls the case, People versus Cody Jolly. Zoom, zoom.
Andrew Childress appearing on behalf. Yes. Did you ever have any luck? Oh. No. I'm sorry, no.
Mr. Jolly?
Yeah.
He's unmuted. Well, he's muted, so I can't. Mr. Jolly, can you hear me?
Jolly.
I know he hasn't been up. Is he responding at all to us?
No, Your Honor, he's just sitting there.
Okay. What are we gonna do on this?
What I can tell the court, there was discussions between myself, Mr. Jolly also has cases pending in 15th District Court. Prosecutor there had spoken with jail staff about possibly getting a petition if the CMH worker in the jail. That does not appear to be something that can be done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's a 15th District Court prosecutor, and Mr. Gaddy Mr. Gaddy just kind of going as scanned by counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution.
Actually, Your Honor, Mr. Chablowski and I, Mike Getty from the Public Defender's Office, Judge Perry he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down. It was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance. We're hoping to go tomorrow.
Okay.
So we did attempt to see him, but he didn't refuse us. But I mean, to be candid, he's refused everything else.
What do you wish for me to do?
I'm merely a reporter in this.
Yeah, no, I got you. Well, until we can figure something out, I mean, this is sort of at a standstill. I mean,
I guess at this point, we'll give them another chance to see if we can have some sort of conversation.
That's fine. So what I will do, I think, haven't we sent him for comp already?
He was found competent, although the thing that struck me about that is that CFP relied on her earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 2025, 9 a.m.
Thank you.
Bond continued. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.